Using implied terms to attack discretionary decisions is what we're going to move on to now. And really, the development of implied terms has made the injunction jurisdiction considerably more interesting in the sense that there is potentially now a much greater scope to attack decisions in the High Court as opposed to having to wait until the dismissal has taken place and going to the employment tribunal. Because with express terms, say of a disciplinary procedure, it might say, for example, well, you're entitled to service of the case against you 3 weeks before the hearing, and you get it 2 weeks before. Are you going to go to the High Court and ask for an injunction to stop them going ahead with a disciplinary hearing because of short notice? Probably not, unless you can show that that in some way has really impacted on the ability to prosecute your case. But implied terms give much more potentially of a scope to intervene with the things, with more substantial matters, which drive at the heart of the process and its fairness. Mark has already referred to suspension as being a decision that has been apt for being challenged by use of the implied term. Most procedures will say you are entitled to suspend an employee, and yet the courts have said, yes, that's right, but you can't suspend an employee if there is, say, no basis for it, or if the suspension goes too far in order to protect the interests of the employer. In those circumstances, it can be a breach of the implied term of trust and confidence and not something that is contractually permissible to do. But the two other topics that I've put up there, categorization and grading, are two topics which have very much come to the fore recently. When I say categorization, I mean, what sort of concern is it? Is it a conduct concern? Is it a capability concern? Is it a matter of ill health? And when I say grading, how serious is it? Is it gross misconduct? Is it serious misconduct? Is it minor misconduct? And those features have made their way into recent cases. Categorization, first of all, was considered in the case of Matu, and there the issue was it personal or professional misconduct? It mattered because of the particular procedural protections that Dr. Matu was entitled to if it was professional misconduct rather than personal. And there, one of the issues that was that the court considered is, well, to what extent can we intervene? Is it for us to say, the trust, you're right or you're wrong about your categorization decision, or do we say, well, provided that you've reached a reasonable decision that falls within a margin of discretion, or as employment lawyers what would say, the band of reasonable responses, then we won't intervene. And there the court said, no, we intervene. We get to decide whether you're right or wrong about categorization, in the same way that we get to decide whether you're right or wrong about the suspension. Is there a basis for it? We can say, well, you are right that this is a conduct concern, or you're wrong about it. But for some comfort to employers, they did go on to say that they would be slow to interfere with a decision of an independent panel about the nature of the concern. So if it was a properly reasoned decision, then was the court going to second guess? And in that case, they said not. I'll now come on to talk about Chabra, and I'll talk a little about the facts of Chabra, because Chabra is a case that straddles a lot of these issues. It looks at categorization, it looks at grading, and it looks at another facet of fairness, and it broadens out the scope of implied terms even further from the implied term of trust and confidence, with the recognition of what the court described as an implied right to a fair procedure in the employment contract. Chabra was something of a day out for Old Square Chambers, because we were the leaders and juniors on both sides of Chabra. Dr. Chabra remains a consultant psychiatrist working for the Trust, and at the time of the events with which the court were concerned was working at Broadmoor Hospital, which needs no introduction. The allegations in the case were that she had read patient confidential material on a train, and she had dictated patient reports on the train, and that had been reported to the Trust as matters of concern. An investigation was ensued into the concerns, and there was no finding of willful misconduct by the investigator. The investigator found that the allegations could be upheld, but noted the explanation that the doctor had given and didn't go on to say, I consider that this was deliberate or willful on the part of the doctor. It becomes relevant later on. There were some other concerns about team working skills, which were accepted to be capability concerns about the doctor's medical practice. And the Trust decided to convene a disciplinary hearing to consider the confidentiality concerns as disciplinary charges, and told Dr. Chabra that they were being considered as allegations of potential gross misconduct. And of course, as everybody knows, under the ACAS code, there is a requirement to tell the employee in advance how seriously you're potentially regarding the matter, and therefore what might be the consequences of the hearing. So there was an application for an injunction, and I should perhaps make it clear that in Chabra, the matter went straight to trial. There was no interim injunction stage. It was decided on both sides that there was a triable issue, and therefore it should proceed to a speedy trial. So the issue was whether or not there ought to be a permanent injunction as opposed to an injunction pending trial. One of the issues concerned categorization, as I say. In the particular disciplinary procedure, which was derived from maintaining high professional standards in the modern NHS, it said, as is set out on the slide, conduct and capability should usually be dealt with together, although there may be occasions when it's necessary to pursue a conduct issue separately, and the Trust had decided to proceed with conduct separately. The policy went on to say that it was for the employer to decide on the most appropriate way forward. And for Dr. Chabra, it was argued that necessary meant that it had to be demanded by the circumstances, and that the Trust fell short of that. And Lord Hodge said, no, necessary is what is appropriate in the circumstances. So gave rather more leeway to employers, pointing to the fact that it said it was for employers to decide on the most appropriate way forward. So whilst Matu is perhaps more black and white and says, no, it's for the court to decide, Chabra does suggest that there is some leeway to the employer if, as is often the case, the policy says that it's for the employer to decide what ought to be done. As I've said, categorization usually matters because of particular procedural protections. But I've just put up there, and it's in your materials, that categorization can matter in a broader sense. If, for example, you've got termination for some other substantial reason, personality clashes, team breakdowns, and there is, and I've sort of put it up there as a possibility that you might have an employee who says, well, I want to injunct my employer from considering terminating my employment for SOSR. This is really a conduct issue. It's really a capability issue. And I'm entitled to have my procedural protections and to clear my name. I don't want a process that is truncated, and I don't want a process where perhaps it might be argued that people will think, well, actually, there's no smoke without fire. And this is really a conduct or a capability issue which is being looked at in a different way. And certainly the courts are concerned, and I've put the quote up there from Leach, that SOSR shouldn't be misused, whether it's in an unfair dismissal context or in a contractual context. But returning then to Chabra and the grading topic, and this is possibly one of the more significant features of Chabra. As I mentioned earlier, the disciplinary charges against Dr. Chabra were graded as potential gross misconduct. And it was argued for Dr. Chabra that the report didn't support that. The report, yes, said that the allegations could be upheld, but didn't find that there'd been willful or deliberate misconduct. And the Supreme Court agreed and said, and I've set out the quotation there, "I do not think that the findings of fact and evidence which Dr. Taylor recorded were capable, when taken at their highest, of supporting a charge of gross misconduct." And then they refer to Dunn and Wilson and Raicher and say, to have gross misconduct, it must be conduct which could involve a repudiatory breach of contract. And the mere, I use the word advisedly, act or the concerns in the case were not sufficient to support a charge of gross misconduct without some additional ingredient. Now, some people might think, well, breach of patient confidentiality is jolly serious, and therefore perhaps surprising that the court intervened. But that is the decision that they reached because they didn't feel that additional ingredient was there. And it is, as far as we know, the first case in which the courts have intervened to say you can't grade a case at that level of seriousness, and therefore it's not right that someone should be looking at potential termination of employment. I'll come on then to talk about sort of some of the breaks, if you like, on what you might think from Chabra is more of a interventionist approach on the part of the court. But just one other feature of Chabra. There was, as I mentioned, the recognition of the implied right to procedural fairness as a feature of the contract. It had been breached on the facts in Chabra, the court found, by the fact that the investigation report that had been produced by the investigator had been the subject of amendment by HR. And it wasn't amendment merely to correct typos or to make sure that everything was being addressed. It actually aggravated the conclusions of the investigator. And the court was critical of that and said that that breached the implied right to procedural fairness. And the query to what extent the implied right to procedural fairness takes beyond the implied right of trust and confidence, potentially it does, because it recognises that a procedure, a disciplinary procedure, has to be conducted in a way that can be regarded objectively as being fair and reasonable. But it does not mean that every decision that an employee is unhappy about is amenable to an application for an injunction. Because as the High Court said in Kulkarni, and as was endorsed by the Court of Appeal, it is not the role of the court to micromanage disciplinary proceedings. So you can't go to court and say, I got the report 3 weeks, 2 weeks before the hearing, and I should have got 3 weeks. That's really unfair. The High Court are going to say, this is just not our job, go away. That really is something for you to sort out internally. And that was echoed in Macdoom, where Mr. Justice Betsan said, the parties have agreed for a process, and part of that agreement involves letting the process take place. So it's not each and every complaint that will lead to an injunction. And because the effect of an injunction is to stop the procedure from going forward, in most cases, because that is what the employee will be asking the court to do. So what does the future hold following Chabra? As I said, and as should be apparent from the previous slide, it doesn't mean that now every case goes to the High Court and every case is ripe for an injunction, because the courts will be careful to ensure that there isn't micromanagement. But as I've put there on the third bullet point, will we see unfair dismissal arguments before the event? Because if there is now, as there is following Chabra, an implied right to procedural fairness, we may well see arguments, typical, traditional, unfair dismissal arguments being run in the High Court to try and stop the case from ever getting to the dismissal stage. So, for example, somebody might say there's no basis for this charge against me. So this can't even start off as a disciplinary investigation. Or somebody might obviously complain about their suspension, or they might say that the investigation has taken too long, or there is something about the investigation which is inherently unfair, not seeing particular documents, not seeing particular statements. Might say, this is disparate treatment. I know of at least 6 other people who've done this sort of thing, and nobody has ever been investigated, let alone had disciplinary action taken against them. And therefore, it strikes at my implied the implied terms of my contract. It's a breach of the implied term of trust and confidence. It's a breach of the implied right to procedural fairness in the conduct of disciplinary proceedings, because you shouldn't even start disciplinary proceedings if it's unwarranted, and it is unwarranted if I'm being treated differently to other people. But these are arguments that we're very familiar with in an unfair dismissal context, but it would be very interesting to see whether people now deploy them in order to support applications for injunction in order to prevent getting to a dismissal, really for the reasons that Mark alluded to, namely that if you get to the dismissal stage, then remedies are very limited because of the cap on unfair dismissal compensation in the tribunal, and because of the strictly limited financial remedies available in civil proceedings, namely you're tied to the value of your notice period. I've put the Gies and Smith and Trafford housing cases up there because it perhaps goes to the point that Mark was talking about of losing coherence in employment laws, because arguably we now have lost coherence in employment laws, because Gies says, well, even if you are dismissed, even if the employer says you are dismissed, you can reject a dismissal which is a repudiatory breach of contract and treat the contract as still being alive. So the mere fact that the employer gets to the dismissal stage doesn't mean that it's game over as far as an application for injunction is concerned. But of course, as everybody knows, in unfair dismissal, an EDT is the date on which the employer says you are dismissed. And therefore now you genuinely have the prospect of 2 termination dates. One termination date for unfair dismissal purposes, and one termination date at common law if the employee says, well, actually, I don't accept your termination. Your termination is in breach of contract, and I would like to apply for an injunction to prevent you, to restrain you from putting that purported dismissal into effect. Just a thought there. But Smith and Trafford housing is also interesting. I describe it as the gay marriage Facebook case because I assume everybody will know what I mean if I describe it that way. It was the case of the unfortunate employee who made certain remarks on Facebook about his views on gay marriage and was disciplined but not dismissed by his employer. He was he went through a disciplinary process and he was demoted. And one of the curious features about that case was that whilst Mr. Smith won his case, he persuaded the court that it was wrong that he was demoted because the contractual basis didn't exist for him to be demoted. There was then an argument about whether he'd been dismissed or not. And he was saying, well, it's a breach of contract, but I have chosen to affirm the contract but sue for damages. And the employer was saying, well, if we did demote you and if we didn't have any right to do it, then we dismissed you on the Hog and Dover College principles. And the court said, yes, that's a Hoggandover College dismissal. So a final thought, a brave employer might say, yes, I have done that of which you have accused me. Yes, it's a breach of contract, but it's so bad that it actually amounts to a dismissal. And therefore, you can't have any financial remedy beyond your notice period. I suspect that nobody will actually do that. And if threatened with an application for an injunction or High Court proceedings generally, will say, well, actually, I didn't do it, or if I did, it certainly doesn't amount to a breach of contract, and it's not apt for an injunction because it amounts to micromanagement. But I think it's a little bit of watch this space at the moment.